applications and appeals in the matter of Mapara and others and Demetriou.
Yes, Mr. Kitson.
My lord, my lady, I appear on behalf of the appellant
Yes.
alongside Miss Cool, and Miss Gatti appears
Yes.
for the respondent. You should have a number of bundles.
We have.
I don't know whether or not it would be useful for me to check that we're all working off the same hymn sheet, but there are two bundles of the appeal. There's an application bundle.
Yep.
And there are some bundles of authorities,
Yes.
both in relation to the application
Yes.
and to the appeal.
And we must deal with the application first.
Of course. It is not without a modicum of trepidation that we make this application on the first day of the appeal. What we're seeking to do is to amend...
Then we know what you're trying to do.
Sorry. Oh, it's a conflict. My learned friend quite rightly has reminded me that there is an issue that we wanted to draw to the attention of the court, and that is that there's a gentleman who I think works in the criminal division, an associate, who is called Max Balisaria. He's a committee member of the association, the respondent to this appeal, and he's not present in court, but we felt it was right to draw that to the attention because we understand that he may well have had dealings with your ladyship and your lordship. We take no objection to it whatsoever, but I've been asked to make that.
Well, now your application is to amend the grounds of appeal.
Yes.
To insert an additional ground.
Yes.
To withdraw 3 of the extant grounds. Four. And to serve skeleton arguments both in support of your amended notice of appeal and the cross appeal.
That's correct, yes.
Now, the withdrawal of the 4 grounds of appeal is not controversial.
No.
So, unless your proposal to withdraw that is conditional on success on your application to insert the new ground, we needn't bother with that.
Yes, I'm grateful for that indication. Yes, we withdraw those grounds 1 to 3 for the principal reason that we don't think it's right to be arguing that the Court of Appeal should be making declarations in a vacuum. Declarations which, on the face of it, concern rules and regulations that over the course of these deeds, which are 999-year terms, the Court of Appeal should be considering, as the trial judge did, the actual regulations
Yes.
that were in place at the time. And we felt that that was not right.
Yep.
When we came on board last Wednesday to represent the appellants to advance those appeals. And the 5th ground we felt wasn't proportional, and it wasn't a proportional use of court resources to be arguing about something which would have a commercial benefit of £7,000.
Right.
So that's the reason for that, my lord. In relation to ground 6, which is the ground of appeal that we seek permission to rely on in this appeal, what we say in relation to that is that it is a pure point of law. It depends on the construction of the deed and looking at the terms of the deed and whether or not Section 78 of the Law of Property Act has effect that means that successors in title don't have to be named within that clause in order for that benefit under that clause to be transmitted to successors in title. That is our point on that. We say it is a straightforward point.
Well, your first point is that the right granted by the deeds is a proprietary right.
Yes.
Yes.
That's right.
And there is learning going back to 1828 or thereabouts discussing the nature of burial right, and nobody has ever decided what it is.
No.
So that's a completely novel point. And there's a decision of Mr. Justice McNair which says it's not a property right. There's a decision of the Court of King's Bench which discusses the question, and at least one of the judges says it's not a property right. There is a decision of Mr. Justice Morritt which says on the construction of the particular statutes he was looking at, it's equivalent to a property right.
Yes.
So to say that it's straightforward, I think, if I may say so, is an understatement. Section 78, assuming we get to Section 78, the question there is whether Section 78 simply extends the class of person entitled to enforce a covenant in the form in which it is drawn, or whether it changes the substance of the covenant.
Yes.
Which is also, if I may say so, not a straightforward point.
My lord, in the first point you raise about burial rights, there was an acceptance at the trial, I think on the very start of the trial, that the burial rights were proprietary. There was no exploration as to what the actual nature of those burial rights were, which are the burial rights under clause 1.
I'm not sure that it was conceded with respect. It was conceded that Mr. Demetriou was bound by them, but the way I think Mr. Palfrey was putting it was that it might be a licence coupled with an interest. That's
right, yes, and we would say that that is the most likely way in which.
So then the question is a licence coupled with an interest proprietary?
Well,
to which I have no idea.
Well, my lord, certainly the indications are that indeed in Gale on Easements, which is an authority that my learned friend relies upon, is that it is of a proprietary nature, albeit it's.
I don't think Gale says that. It says there's no doubt about the validity. That's all it says. But
yes.
Nobody knows what its juridical nature is.
No, I have to accept. I have to accept.
And the judge specifically quoted at paragraph 27 the extract, which says the nature of the right created is questionable.
That's right. Yes.
Which suggests that it wasn't common ground below.
Yes, that must be right. Yes. That relates to the right to bury, and that isn't, strictly speaking, an issue on the appeal, insofar as the right to bury is not the covenant that is the subject of our application to amend ground 6. It's the right to dig.
Yeah.
And in a sense,
you've also got to say that the agreement and declaration is a covenant.
Yes, and we say it is a covenant insofar as it touches and concerns the land in question.
Well, that's the second question. The first question is it a covenant at all? And if it is, then the question arises, does it touch and concern the land?
But we say it is a covenant. It's an agreement. It's one of the agreements between the grantor.
That I understand.
And the
grantee. The scope of Section 78.
We say it must be a covenant. It is a covenant made in the context of the deed, the grant of the right for burials, and within it an agreement and a declaration that there is a right to an exclusive right in the case of most of the deeds in question for the original grantor to dig the graves, and we say
all right. Well, I mean, he could characterise it as a reservation rather than a covenant. Now, I'm not saying you're wrong, Mr. Kitson.
No.
I'm taking issue with your instructing solicitor's statement that this is a very straightforward point of law. It is not.
So big, my lord. I have to accept that. What we say is it is a point that was dealt with at the trial below. The question of the issue of the proprietary rights was something, in relation to the burial rights, was something that was dealt with below, and indeed Section 78 features in the transcript as being one of the points that was advanced before the trial judge by Mr. Gatti.
I thought he was just explaining to the judge why it didn't apply, and Mr. Palfrey made no contrary submissions.
But Unhappily, we don't know whether or not that's the case because the transcript runs out because there was a problem.
Right.
There was a problem with the.
Well, if that had been an
recording.
issue, it's surprising the judge didn't deal with it.
Yeah, I must accept that, my lord. But Section 78 was certainly mentioned during the course of the trial below. We say that it is a point that can be dealt with in relation to the requirements under Section 78 for the benefit of what we say is a covenant will run with the land, and in those circumstances we say that the land is identifiable under the deed, and we say it touches and concerns the land, and my lord, in our skeleton argument we referred to a few authorities in relation to that, and we say that there's no contrary intention in the deed to exclude Section 78. We say they are really the critical points that have to be dealt with in the context of the amendment application, if it was to be granted. If it isn't to be granted, then we say that, or we still rely on ground 4, and of course we will oppose the cross appeal.
Yeah.
For the very reasons, principally, why we're not proceeding with grounds 1 to 3. Now, in terms of the relevant test for amendments that are late in the day, as this one is, there does appear to be a little difference between the parties as to the approach that the Court of Appeal should take in the circumstance of an amendment to an appellant's notice. We say that the right test is set down in the Clark and Lighting decision, which deals specifically with 2 scenarios, one being where an appeal notice is put in late, where there is a breach of a rule or practice direction, and when there is an application to amend an appeal notice at a later date. And we refer specifically to paragraphs 31 and 32 of that authority.
This is in paragraph 9 of your skeleton argument.
It is.
To avoid turning up the authority. To avoid turning up
Yes,
the authority.
that's right. Yes, I set that out
Yes.
to avoid
Yes.
time in having to do that. And your lordships will see from that there is a distinction that is drawn there as between extending time for the filing of an appellant's notice and an application to amend an appellant's notice. And what we say is and it's supported by the notes in the White Book it's on page 1907, that the correct approach.
Just a minute. (1907), yes.
And it's 3 lines up from the bottom of that note. It may be permitted subject to the general principles governing amendments. And then there's a reference there to the commentary in part 17.
Yeah. Now, in the Clark case, have I got this right? What was being challenged was a refusal to set aside a judgment on the ground that the defendant wasn't there.
That's correct, yes.
So it's a single order being challenged.
That's right, yes.
Here it's a separate declaration being challenged.
I must accept that, but it's we seek to challenge it by way of amending the appellant's notice.
Yes.
What we say is that the authority.
So if for instance, a judge decides that X is liable to Y in damages and assesses those damages at Z, you say that if you appeal against the quantum of damages only, then any appeal against liability is simply governed by rules about amendments, because you have put in an appellant's notice.
On time, within the rules, yes. We do say that. There is very limited authority in relation to this, the approach of the court in circumstances where there are amendments and the types of amendments that may be made to grounds of appeal or the introduction of new grounds of appeal. That was a case where there was an application to introduce a new ground of appeal. But I do take your lordship's point. It is different insofar as this is an application to appeal a different paragraph of the order. And in a sense, the tests, we say the test is based on amendment, but of course we acknowledge that Denton is going to have some relevance in that, because that is what the court says in the Clark and Lighting decision. So we accept that there will be some conflation of approaches as a result of that.
Yeah.
But what we do say is that the starting point is the rules on amendment, and we say that's quite significant in one way, and that is that the merits of the point of appeal are significant, and indeed it's the first factor that is mentioned in that case. So we, first of all, whether there is a real prospect of success of the amendment succeeding. Secondly, the lateness of the application and the reasons for that lateness. I deal with this at a paragraph in the skeleton argument, but the earlier history between the parties, the need for an adjournment, and the effect that the application would have on the litigants and the litigation generally. What we say in relation to that is that there is a strong basis for contending that this particular covenant, we call it a covenant, in paragraph 4 of the deed, there is a real prospect of success in advancing that argument. In terms of the lateness of the appeal, we've explained that as well as we can in the witness statement supporting the application. Your lordships and my lady will appreciate it. It was a point that has been raised late in the day. It is a point that wasn't argued, we think, at the trial, albeit it did feature at the trial. And what we say in relation to that is that should be a compelling reason to put into the weighing scales when deciding whether or not.
Sorry, what's the compelling reason? That it wasn't argued at trial?
No, that it does have a real prospect of success.
Oh, I see.
And it's a point that can be dealt with reasonably neatly. I accept my Lord Lewison Lord Justice Lewison sees complexities there which would need to be explored in relation to the covenant and the application of Section 78. But we say it is something that can that can be dealt with at this stage.
Today?
My Lord, yes. That is the basis upon which I advance the application.
So you're not asking for an adjournment?
No, we're not asking for an adjournment. I understand that if and to the extent permission was granted to amend the appellant's notice or to introduce the appeal of a different paragraph of the judge's order, then my learned friend's position is that he would want an adjournment, and that he would need about a day of work in order to prepare the response to that part of the appeal, if permission is granted. In relation to delay, I can't say much more than it is a point that arose last Wednesday in the context, the Wednesday evening, or well, actually slightly after that, because that was when Miss Macur and I were instructed in this appeal, and we felt it was a point of importance in the case, and indeed a point that was going to be for the benefit of all concerned in relation to certainty as to what the rights were in relation to the digging of the graves. And we say that the benefits and the justice go beyond just these parties, because this is an area of land which is used for a very sensitive purpose. There have been in the past serious issues in relation to the digging of graves, putting bodies on top of another body, bones being found. This is dealt with in the witness statements. I do have the references if it assists.
I think it goes both ways, though, doesn't it? That there are complaints both ways, which is what started the proceedings.
That's right, complaints both ways,
Yes.
but and indeed maybe third parties as well. The identity and the reason why for example, bones have been found or graves have been dug is something which we feel strongly, my clients feel very strongly, that they need to have control over that, which is often the case in statutory cemeteries. And in a sense, it creates a very important set of circumstances where only they are entitled to dig these graves, and we say that's very, very important. And that's not just important for my client, and I accept there is some commercial interest in there, because there is the deed provides for the payment of a sum, which we've always accepted would be a reasonable sum, and indeed there would have been an assessment of that sum, as you would have seen from the judgment before the judgment given by the judge below. The points that are taken against us in the witness statement by Mr. Foster that was filed on Monday. The points taken, I've categorised them as sort of following. There is some different ways in which the same points are being taken. The principal point that's taken against us is in relation to delay. A point's taken that it is a new point that wasn't argued below, and the third point is that there is a change to the scope of the appeal hearing. Yeah. If I can just deal with that one first, the change to the scope of the appeal hearing. There are 9 deeds that are relevant in this case. They date from 1985 through to 2004. They are all in slightly different terms, but not in a material sense for the purposes of the appeal that's being advanced before the court, save in respect of one deed, and that's the 1985 deed that can be found in the supplemental bundle at page 164, because that deed doesn't provide for digging rights. And so any digging rights that would be imposed in relation to the plots of the grave plots in relation to that deed would need to be imposed by regulations, if that was permissible to do so, because there is no clause 4 in that particular deed. As for all the others from 1987 through to 2004, there is a clause 4.
Yeah.
I'm sorry, it's at 164, the 1985 deed. So there is still relevance in the cross appeal And indeed, there'd be relevance in the cross appeal, even if we were able to advance ground 6, because we may not succeed on ground 6, and therefore the cross appeal is still is not a wasted cross appeal on the basis
the cross
that
appeal is live.
Absolutely.
Yeah.
Absolutely. There seemed to be some suggestion that it changed the appeal hearing, and that the cross appeal would become redundant if we were advancing the ground 6. In relation to the new point argued, whether it being a new point argued that wasn't argued in the court below.
Well, I think we've been through that, haven't we?
Well, I was going to refer your lord, my lord, to the authority on that, but it is
Sing Das.
yes. But I don't want to take up the court's time unnecessarily in relation to that. We say that when looking at the amendment line of authorities, it's very clear that there is this weighing up of factors. And your lordships will no doubt find some factors more compelling than others, and in the weighing scales will decide ultimately whether or not we get permission or not to make that argument. What we would say in relation to that is that when looking at delay, it is a relative concept insofar as we say it is a point that can be dealt with at the appeal, and there is no need for an adjournment. And in circumstances where it is a legal point, which can be argued without any change to the facts were actually not contested at the hearing below. It was dealt with by way of legal argument. Then in those circumstances, those factors must weigh heavily in the weighing scales.
Yeah.
A further point taken against us in relation to the application is alleged past breaches. We accept that there has been delays in the preparation of the appeal bundle, but they are, in a sense, they're not breaches of rules and practice directions they are extensions of time that were granted by the court office. So we say that is not something that ought properly be taken into account. And in relation to complaints about the bundle, the court gave us an extension of time in relation to the bundle. We applied on the...
Well, I think we're going to take a broad view.
Well, my lord, they're my key
Yes.
submissions in relation to the application.
Right. Mr. Kitson, we are going to refuse your application for permission to appeal. This is a very late application. In substance, it's an application for permission to appeal a different part of the order way out of time on a point not argued below, and I will give further we will give further reasons in the judgment, but the answer is no. As far as the skeleton argument in opposition to the cross appeal is concerned, subject to what Mr. Gatty has to say, we are minded to allow you to rely on it, since you are not debarred from participating in the cross appeal, and it is as convenient to have your submissions in writing as to write them down when you make them orally. Okay. So, Mr. Gatty, do you want to maintain your opposition to the supplemental skeleton insofar as it relates to your cross appeal?
My lord, no. It's here. It provided. It was helpful to have some foreknowledge. So.
Right. All right. Right, Mr. Kitson, your appeal.
My lord, I have one ground of appeal,
Yeah.
and that's ground 4. It relates to the scope of the declaration that was made by the judge. We have prepared an alternative wording, and it may be useful for your lordship's to have that. So
Yeah.
you,
Well, your complaint is that the judge didn't follow the wording in the deeds. I understand that
Yes.
complaint, apart from one deed. But what is the practical difference between plots and areas? I can't myself see plots when I look at the plans attached to the deeds. I know the deeds in words refer to plots,
yes.
but how do we identify plots?
We don't, and that your lordship makes a point that's very much alive to us, that there is an area of land specified, and there is a number of plots for burial on that site. What we understand is that the area of land can accommodate more than the plots in question, and that it isn't an exclusive right. Excuse me. It isn't an exclusive right that's granted in respect of the whole area. It's in relation to specific plots, save in relation to one deed.
Well, just a minute. So you say that the areas can accommodate more plots than the number specified in the deed.
Yes.
And was that common ground below?
No. Not that I'm aware of. But
How do we know if it's correct or not?
they're my instructions, my lord. I can only go so far as that. So in terms, if I could hand up what we propose in relation to Declaration 3 in the order, because the order, Declaration 3 does conflate two things. It conflates firstly the dumping of rubbish, and we're not challenging the declaration in relation to that, but it also deals with the burial of bodies in plots. But it deals with it in relation to the areas, not the plots. So we've separated that out so that we could hopefully give the Court of Appeal some clarity in what it was we were seeking in relation to the ground 4 appeal.
Yes.
So the ground 4 appeal can be taken shortly, and so far as that all we're seeking is that there is an acknowledgement that it's about the use of the number of burial plots over which the burial rights were granted, rather than the area of the land within the red line on the plans. And that the declaration ought to have reflected that, because there's one deed that deals with the area, and we accept it in relation to that. But in relation to the plots,
But how is this going to work? The association trustees have got the right to bury, let us say, 150 bodies in plots in a particular area marked on the plan. Is it up to them to choose where to have the plots?
well, I think that part and parcel of the digging are us digging the graves where they
Well, that's a separate question,
go. But I accept that's a separate question.
Is this all about your client wanting to use up the space that he says exists there?
Yes.
So he wants, in the space that he's granted, to put in more plots because it's not as intensively used as it is.
Absolutely, and my understanding is that there is great pressure on availability of space for burials, and that's the reason. And there are already third-party graves there, I'm told. That's the context in which we advance this ground for.
So the third-party graves have been dug when?
Well,
Since the the deeds were in operation?
Yeah, since they've been in operation.
And
yes.
was there any evidence of that before the court?
My lady, it's an important point, and I'm just asking those behind me to clarify it.
I'm sorry, I missed the answer to my lord's question. What does the appellant say regarding the association's indication of where the plots for their members should be cited?
The
May
deed
have
doesn't
particular
provide for it,
significance.
my lady.
No, so who would determine it then?
Well, I don't know is the answer to that. It's an area of land, and in a sense, that's one of the reasons why control over the digging is an important factor. But I accept that point is gone. But
Well, why would control over the digging also indicate control over where to dig?
well, there are regulations and rules that can be introduced, and no doubt they could deal with that very factor.
I don't suppose the parties have mediated this at all, have they?
There was a mediation.
But it failed.
Unhappily, it failed. I'm
Yeah.
told it was about a couple of weeks ago. I mean, it is a case that one would have hoped would have been eminently settleable at a mediation, but happily that wasn't the case. So, my lords, my lady, what we say is that the declaration should give some acknowledgement to the fact that it's about plots and the right to bury in plots rather than in the entire area. I can't add much more than that.
All right.
Unless you've any further.
James?
No.
Yes, thank you, Mr. Kitson. Mr. Gatty.
My lord, my lady, just on a couple of points of fact that arose in the course of Mr. Kitson's submission. So, my understanding, and I'm not seeking to give evidence, but as I believe the evidence was at trial, was that the only time post the deeds that anybody had been buried in these grounds, other than members of the association, when I say these grounds, I mean the areas of the deeds, after the grant of the deeds, was an instance which was one of the triggers that brought about, it was by Mr. Demetriou, and it was one of the triggers that led my clients to issue proceedings and seek an interim injunction.
Is there any evidence about that anywhere?
Well,
If there is, I haven't picked it up.
not in the appeal bundle. The evidence would have been in the witness evidence
Before
that
Mr.
was
Justice
before
Mann.
Mr. Justice Mann. I'm afraid that isn't in the appeal bundle. I'm sure I have it on my system and could get it to your lordship, but I don't have it. But your lordship doesn't have it at present. It's right to say that in some of these areas there will have been old graves which can't be buried in until a certain period of time, and your lordship will have noted that the deeds are expressly made subject to any existing burials in those areas. So there is, as I understand the position, a statutory. It's possible to reuse a grave after 50 years. So there will have been some old graves in those areas which aren't usable yet, and that. But in terms of any new graves post the grant of the deeds to the association, the only one that I'm aware of, at any rate, is the one that generated litigation.
Yeah.
Now, the second point of clarification is as to whether or not these areas of land can accommodate more than the plots that were allocated in the deeds. And there wasn't at trial any clear evidence about that. There was, I think, in the run-up to trial, an attempt by both parties to get some surveying evidence which didn't produce anything that was fit to go before a court. But I do refer to my skeleton argument at trial, which is in the supplementary bundle, and it's paragraph 8.5, page 92 in the supplemental bundle. And this was as part of the argument that I was summarising in my skeleton as to whether or not it would be possible to bury, for Mr. Demetriou to bury in these deeds. And you'll see that at paragraph 8.5, I say it's reasonable to infer that Badghurst is likely to have ascertained the areas to be granted with reference to the number of plots that they would fit, save for the 11-2-1990, because that's the one that doesn't specify a number of plots, just specifies an area. Make no economic sense for Badghurst to grant rights over a large area than was needed to bury the specified number of bodies, and refers to a letter. Now, pausing there, the issue wasn't resolved before the judge. That was our case. There was no evidence to gainsay it. In terms of the letter, that unfortunately isn't in the appeal bundle, but I have just looked it up. I looked it up the other day in the hearing bundle. It's a very short letter. My learned friend may not have seen it, but since it's referred to in the skeleton argument, it might be helpful if I just read it out. It's a letter dated 27th of October 1989 to one of the then
98,
trustees.
the skeleton says. That's wrong, is it? It's 99.
In that case, that was yes, that was a typo in
So
my.
it's 89, not 98.
It's 89, so that was my error. October 27, 1989, Mr. Bam, who was one of the then trustees, 75 Rayton Road, etc. Dear Mr. Bam, this is from, I should say, P.R. Budge, Director of Badghurst Limited, on Badghurst Limited's note paper. Further to our meeting on site yesterday, I have now inspected the files on the transactions and have found that I was incorrectly under the impression that the grave spaces leased to your association was 3 foot wide, but in fact the space allocated per grave is 2 foot 6 inches, and therefore the amount of land fenced is correct. I would apologise for my error. So that, for what that's worth, it seems to support the proposition that what was being granted was the amount of land that was needed to accommodate the number of plots, and that's what one would expect when.
1985 deed was specifically referring to 86 plots. Is that right?
I would have to look that up, but all bar one did refer to specific numbers of plots.
Yes, so does that assist your argument, or? Because the deeds thereafter changed in terms to some extent.
Well, they did, but the majority of them, if not all of them, bar the one, do refer to
areas rather than plots.
A specified number of bodies or plots. So if we look, for example, at page 112 in the supplemental bundle, which is the last of the deeds, which is 27th of October 2004, that grants unto the grantee the right of burying 117 bodies and all those 117 plots of unconsecrated ground within the area shown edged red on the plan annexed here too. I'm not proposing to go through all of the deeds, but just looking.
Well, the one at 117 talks about the right of burying 115 bodies in that partially unconsecrated ground in the area shown edged red.
Yes.
Page 131, right of burying bodies in that partially unconsecrated ground in the area shown red. 136 is the right of burying 60 bodies in all those plots on consecrated ground within the area.
Indeed. There's some variation as to whether it refers
Yeah.
to plots or bodies, but what they do consistently, bar one, is give you a number and say within the area shown red. And it was my submission to the judge, and it's my submission today, that the obvious inference to draw, in the absence of any evidence, and it's assisted somewhat by that letter, is that the amount of space that was allocated was the amount that was needed to bury the number of bodies that was referred to in the deed. Now, before the judge, there were certain concessions made by counsel then instructed for the defendant, which made it possible for the judge to shortcut matters somewhat in his judgment, and those concessions are reflected in paragraphs 51 to 52 of the judgment, which is on page 93 in the core bundle. Unfortunately, although it was a virtual hearing and recorded, the recording failed at some point, and so we don't have those concessions being made. But we do have the judge's description of them under the heading the fourth issue, and nobody has suggested...
The page reference again.
It's page 93, my lady.
Thank you.
In the core bundle. Nobody has suggested, certainly Mr. Palfrey, when he was instructed in his skeleton argument, didn't suggest that this was an incorrect description of the concessions that were made. And we see that the defendant was accepting there that the claimant's rights under the deeds are such that the defendant is not entitled to arrange or permit burials of persons who are not members of the association. Now there was some issue, and we see referred to there, which I raised as to whether or not, as a matter of construction, one can actually look at these deeds as effectively leases, because much of the language is the language that one would see in a lease, peppercorn rent, and to some extent it's possible to view them as grants of exclusive possession. But that didn't ultimately need to be resolved on the facts, largely because of the concession that was made by the defendant's counsel. It didn't matter in the light of that concession whether it was a grant of exclusive possession or simply a right to use the space. But in the light of that it was in the light of that concession that the declaration was drafted in the way that it was. And of course it's important to bear in mind that what's being appealed here isn't the judge's judgment, it's the way that it was represented in the declaration. So there's no challenge to what the judge says at paragraphs 51 and 52. The challenge is the way in which that has taken form in a declaration. And so we are looking at an exercise of judicial discretion over that. Whether to grant a declaration is a discretionary question, and in my submission, the language used is a discretion, and one that the appeal court shouldn't interfere with unless it's plainly wrong or outside the realms of reasonable disagreement, or however one wants to put that test. So that's the overarching sort of legal context in which I say the court ought to approach this. Was it plainly wrong for the judge to have used words that he did use in the declaration in order to give effect to paragraphs 51 and 52 of the judgment? Now they're very short paragraphs, I accept, but nonetheless, in the context of the litigation, it can't be said, and in my submission, nothing that Mr. Kitson has said really goes this far, that the judge was plainly wrong to use the language that he did use.
Yeah.
there's a suggestion in Mr. Palfrey's skeleton argument for the appeal, which is still relied on, that it's simply a matter of the construction of the deeds in question. That was the basis of the appeal. That's how it's put in the skeleton argument. But my submission on the construction of the language of the deeds, and we've looked at them briefly, the obvious inference is, the risk of repeating myself, that what was intended to be provided was an area of ground sufficient to, and no greater than that, to accommodate the number of burial plots granted. And in that context, the language that's used is appropriate. And indeed, the difference between areas and plots in practice may make little difference. So that if that were the change that was being sought, but the change that's actually being sought, pursuant to the deeds, and looking at my learned friend's wording that was handed up earlier, the defendant isn't entitled to arrange or permit burials of persons who aren't members of the association in such a way as to deny the trustees of the association the use of the number of burial plots over which burial rights were granted. Well, one doesn't find that in the judgment. It is it's in effect an attempt to row back on the acceptance that is the concession that was recorded in the judgment at paragraphs 51 and 52.
Yeah. Well, in the first sentence of paragraph 51.
Indeed. And given that, in my submission, it really wasn't open to the judge to make a declaration in the form that was is now being proposed in the light of his judgment. And the judge certainly can't be said to be plainly wrong to have made the declaration that he did make. And it's also right to say, and I say this in my skeleton argument, that if one did make the amendment that's sought, the practical effect would be to create conflict. There is, as my Lord Justice Dingemans has observed, this is the sort of case that, in an ideal world, wouldn't be before a court at all, let alone a court of appeal. And there was a mediation recently that failed. Attempts to arrange a mediation at an earlier stage failed largely, we would say, because...
Well, don't go into that, but there have been mediations, they haven't worked.
There have been mediations, they haven't worked. But it certainly wouldn't be sensible for the court to unnecessarily introduce words into the terms of the declaration that will add heat rather than subtract heat from what's obviously a rather sensitive dispute. And if the change is made that is being sought, then there is considerable room for argument and no means of resolving that argument without another piece of litigation.
Well, I'm bound to say that when I read the skeleton arguments, the only reference to this declaration in Mr. Palfrey's skeleton, and I don't think there's any further in Mr. Kitson's supplementary skeleton, was paragraph 21 on page 40, which doesn't begin to explain why the point is of any importance at all.
That's right. And it isn't addressed by Mr. Kitson. He relies on Mr. Palfrey's paragraph 21. So, unless I can assist further on that point, I lose my submission.
Yep, well, you've got your
I'm being, if I may.
My Lord, I've no further submissions to make in response to that.
All right, thank you very much.
So that is the
That's the
my
appeal. Thank you.
if I can just add two things, my lord. First of all, page 118 to 119 of the core bundle does contain the evidence about the unauthorised burial. My instructor says
118 to 119.
118 to 119.
So what are we looking at here?
I believe it is the witness. First, or it's the.
This is Mr. Shake's witness.
Mr. Shakes. I think
And
first.
who is he?
statement.
He's the secretary of the association.
Indeed.
Right. And where does he deal with this?
118.
32, paragraph 32, is it?
I'm just turning it up myself. Yes. And paragraph 33 in particular. 33 and 34.
Right.
And it's right to say that was one of the matters that was relied on when the interim injunction was sought for. And the other point...
Does Mr. Demetriou in his evidence say anything about that? Because we've got a witness statement from him.
He does address it in a... I can't, off the top of my head, recall the reference. But I can hear my own friend.
Paragraph 55, my lord, on page
55?
55 on page 141.
So this is reopening a previous grave, Mr. Demetriou says.
Yes.
Yeah.
So he seeks to justify it right or wrongly, but no dispute that is the incident happened. So the other point that my instructing solicitor helpfully makes is that the covenants given by the trustees in the deeds, and it might be helpful to turn up page 112 in the core bundle here to look
In
at
the
the
supplemental.
2004 deed.
In the supplemental or the core?
Sorry, supplemental.
Yeah. 112.
112. So this is the 2004 deed, and we see clause 2 is some covenants, and then clause 3 that the grantees, subparagraph 3 of clause 2, that the grantees will keep the areas of land in a clean and neat condition at all times, provided, etc. So there was an obligation being imposed on the trustees with reference to the areas of land, an obligation to keep them neat and clean, which in my submission supports the proposition that what was being granted was effectively the entirety, right to use.
That's not the deed which is the subject of the proposed alternative wording, is it? Because that's at page 131. The proposed alternative wording is specific to the deed of the 11th of February 97.
I don't believe it is. That wasn't my understanding. Is that?
I think the general, as I understand the proposed declaration, the general declaration relates to plots, and the 97 deed is the one that refers to an area.
And the proposed amended wording that we've been given this morning is specific to the 97 deed.
That's correct, yes.
Yeah.
Because that is said to be an area deed rather than a
Yeah.
plot.
Yeah, it deals with all of the deeds apart from the reference to the area referred to in the 1997 deed.
Yeah. Well, I
Because
mean,
the others
I have
relate
no idea
to
where
plots.
this reopened grave was, but the deed that you are looking at now does say that the grant is subject to all and any rights which exist in respect of burials already carried out. So there may well be some.
But as I understand the amendment that's being sought to the declaration, it isn't just limited to the 1997 deed. There's a distinction being drawn between the 1997 deed and the others. But it's intended to apply to all of them.
Yeah. All right.
So those were the other 2 points that I
Right.
wanted to make.
Now, cross appeal. Cross appeal.
So, may I just help myself to some more water before I begin that? It's a warm day. Happily not as warm in here as it is outside. The cross appeal also relates to the terms of the declaration, but fundamentally, it's, and in contrast to the appeal, it's concerned with the terms of the judgment. What we say is that the declaration ought to be altered because the court ought to overturn an aspect of the judgment, which is a distinction of significance. The simple amendment to the declaration that we seek is to remove from paragraph 2 of the order,
as they were at the time of trial.
As they were at the date of trial, in order to make it a more general declaration as to what it's possible to do by reference to the regulations, specifically with reference to who can dig and charging for that. Because it was our case at trial, and
well, that's not... The declaration that you want is simply that that Mr. Demetriou cannot, through regulation, insist on digging graves. That is how the declaration would appear without the words to which you object.
It is,
but that's nothing to do with charging. That's to do with whether he has the right to insist at all.
That's right, my lord. The commercial reality is that it is to do with charging, because the dispute between these parties arose largely because so much more was, and effectively what my client's position is as well. We will use our own contractors and pay a lot less, and so it has cost implications. But the key, your lordship's right, that the key paragraph, and I'll take your lordship to the regulations that were relied on at trial in a moment, is the one that effectively says only me or my contractors can dig any graves in the cemetery. That's the key regulation. Now, that aspect of the argument was dealt with in the judgment at paragraphs 39 to 48. So at page 91 in the core bundle.
Yes.
And the way this arose, just by way of background, because it wasn't part of the relief sought in the Part 8 claim form, was it was raised in one of Mr. Demetriou's witness statements, where he says, well, it all doesn't really matter very much because I can do it by regulations anyhow. Yep. And it was obviously sensible to have that considered at the trial.
The key paragraphs are 43 to 45, I think.
They are.
And 48.
And what the judge effectively held was that the current regulations failed for Mr. Demetriou's purposes because they would amount to a derogation from grant, because they didn't reflect, amongst other things, the provision in the deeds allowing my clients to arrange their own burials if he didn't do it quickly enough, which of course is important to people of the Sunni Muslim faith who, like Jewish people, are required to bury as soon as possible. But our case was wider than that, and we say that the judge was wrong to approach it in the way that he did. And it ought to be said that this isn't a hypothetical question. One of the points made in Mr. Kitson's skeleton argument. As this is all very hypothetical, doesn't matter, one oughtn't to make regulations about the future, but actually it's a very live issue between the parties, because, and this probably doesn't emerge from the appeal papers, Mr. Demetriou's response to the judgment was to make some changes to his regulations to try and accommodate the derogation from grant point, but still carry on insisting, requiring that, banning anybody other than himself from digging graves and charging his prices. So it's a very live issue between the parties. And although, as I've already submitted, the question about whether to make a declaration is discretionary, it has to be exercised judicially, of course. And if this court accepts our case, which I'm going to develop in a moment, that contrary to the judge's finding, the defendant can't rely on his regulations at all to require, as to the issue of who digs graves, then that ought properly to be reflected in the declaration that's made. The declaration, the substance of the judgment will be changed, and the declaration to change to reflect that.
Well, the judge's summary of your argument at paragraph 43 doesn't really grapple with the argument that you presented in your skeleton below.
I respectfully agree.
And which is, as I understand it, exactly the same argument that you're advancing in this court.
It is. It sought to sidestep it, and it left the question hanging, and we asked this court to resolve it. And the question, of course, something we say doesn't turn on the meaning of future regulations. It actually turns on the meaning of these deeds. It's about the construction of existing documents. So it is necessary to answer the question that the judge, with respect to him, didn't answer, which is what's the legal basis on which the defendant can rely on regulations to prevent the claimant making their own arrangements to dig deeds. Because, of course, their position is different from someone who doesn't have pre-existing rights to bury at the cemetery. For somebody who doesn't have pre-existing rights, it's a simple contractual matter, very straightforward. If you want to bury somebody within the cemetery owned by Mr. Demetriou, given that rather unusually it's a private cemetery and not effectively regulated by anything, then you have to accept his terms or negotiate different terms with him, or go and find somewhere else to bury the deceased person. But we already have a right, my clients already have a right to bury their members. A right that...
well, I mean, it's important, is it not, to look at the description of the right, which doesn't feature greatly in the skeleton argument, but a starting point would be to look at how the right is described. It is described as a right to bury bodies, and it is difficult to see how you can bury a body without digging a hole to put it in.
I don't bring that point out well in my skeleton, but I respectfully agree with your lordship that is an important factor in terms of what the right is. And I'll say a little bit more about the construction in just a moment, but just to finish this point, ultimately the judge held that there may be some capacity to control these things by regulations without ever identifying the legal basis on which the defendant could do that. Didn't point to some right outside the terms of the deed, nor did Mr. Palfrey below, and nor has Mr. Kitson in his skeleton argument responding to this point. So if there is a constraint on the claimant digging holes, to bury bodies, it can only arise under the deeds. And that's why one has to do what the judge didn't do, which is grapple properly with the construction of the deeds. Your lordship's right that the right granted is to bury, and that necessarily carries with it a right to dig the holes in which to bury. But beyond that, one has to say, well, what else is there in the deeds that could create a right in Mr. Demetriou, just turning up one of the deeds, to say to my clients, you can't and only I can bury bodies in this area over which you have paid reasonably substantial sums of money back into as far as 1985.
What about clause 2.1 then?
Well, clause 2.1 is the only thing that could possibly, in my submission in the deeds, give rise to such a right. But on a proper construction of the deeds, I say it doesn't do that.
One of the deeds doesn't have that covenant in it.
One of them doesn't. But most of them do. I have to accept that. And it was certainly the basis of the argument below was that it was the right to regulate by regulations, which allowed Mr. Demetriou to do what he was seeking to do. Which is why I say, well, given one has to look at the deeds, it can only be as a result of clause 2.1, if at all, that he's in a position to do that. And then that engages the question of what clause 2.1 really means. But before I come to that, one ought to consider the way that the judge dealt with it to some extent, because he distinguished between the position during the first 2 years of the various terms of the deeds, which your lordships and my lady will recall that the deeds, the digging rights say for the first 2 years at such and such price, and thereafter at the grantor's going rate, as it were.
Yep.
So he distinguished between the first 2 years of the term and between the position when Badgehurst owned the cemetery and when somebody else owned the cemetery. But what we say is that covenant to comply with regulations, that can only have the same, must have the same meaning throughout. It can't have a meaning which changes after 2 years, and it can't have a meaning that changes because Miss Badgehurst have sold on the cemetery. Either that covenant to comply with the regulations, rules and regulations, clothed the defendant with the right, or clothed Badgehurst with the right to make regulations to that effect, notwithstanding that there's a separate provision in the deeds relating to that, or it clothes nobody. And it's not, and the question of who can dig is outside the scope of that covenant to comply with rules and regulations. And of course, since this is all a question of construction, a legal question, it's something which this court can approach afresh.
Can I just ask a factual question? Looking at the deed starting at page 131, the agreement and declaration about the digging rights is on page 133. And that clause 4.1 talks about the 2 years. Turn over the... no, I think it's just got...
Out of order, is it?
Just out of order, I think. Yes, I think it's just out of order.
I think so.
I think it's been copied twice,
Yeah.
so I think it reappears on
It's
page
the
1,
same
3,
as
4 and 5.
113,
Yeah.
yeah.
So, in terms of the broad approach to construction, well, I haven't specifically cited it in my skeleton argument, but of course, adopting the usual and familiar approach, most recently discussed in Wood and Capital Insurance Services, to construction of bilateral documents. asking what a reasonable third party, with the background knowledge of the parties at the time, would have understood that covenant to comply with rules and regulations to mean, in the context of a deed which specifically granted the grantor, Badgehurst, a digging right for 2 years, an exclusive digging right.
But it went a bit further than that, because it then said, and in the future, at the rates that are specified,
Indeed.
which would have been specified in the regulations. And if this, as any contractual arrangement could be capable of assignment, for that to have any meaning, it must have contemplated that there was a possibility for the regulations to provide for digging rights for third parties.
Well,
And the judge, perfectly understandably, said, well, let's wait to see.
well, the judge held that the right that was granted, the digging rights under Clause 4, was specific to Badgehurst.
Yes, it was.
And it didn't pass to anybody else. And as a result of the decision earlier today, that's not, that wasn't challenged before, and it's not going to be challenged now as a result of the rejection of the application. So, but the position, so the consequence of that decision is that either at the time of the deeds it wasn't contemplated that there would be a transfer generally, or it wasn't contemplated that there would be a transfer of the digging rights, and they were just a commercial personal bargain between Badgehurst and the trustees, which is what...
That would be a very unusual bargain to make in respect of something where you need specialists to dig graves.
Well, it's the bargain that effectively the judge held below was made, and which isn't subject on appeal because it was held by the judge below, that the digging right was a personal contractual matter between Badgehurst and the trustees.
Well, in paragraph 45, he expressly addresses it. He says it doesn't address the question of digging graves beyond the right to dig beyond reserved to Badgehurst. The successor in title thus has some room to regulate. So he did address it. He said there's some room to regulate so long as you don't derogate from grant.
But that brings back to my question: what's the source of that room to regulate? That's something which the judge doesn't answer, and it can only be the only possible source of that is something within the deeds itself, because otherwise there's nothing else to look at. And the only possible source within the deeds that anybody could point to is that covenant to comply with rules and regulations. So if there is that source, as the judge held there might be, then it's because that covenant to comply with the rules and regulations includes a rule which says only the grantor can, only the owner of the cemetery can dig graves. But if that were the intended meaning of that covenant to comply with the rules and regulations, why, I ask rhetorically, does one find in Clause 4 in the various deeds a grant, agreement and declaration that the grantor shall have the exclusive right to dig graves in the plots of land at the following costs? That wouldn't be necessary at all. You wouldn't require to grant an exclusive right, because if it was contemplated that...
What did the regulations say at the time?
That I'm afraid we don't have the evidence.
Well, and that will be your answer, is because it wasn't in the regulations at the time.
Well,
and because there would be no point in duplicating it. And it then specified what would happen if the regulations changed.
Well, it doesn't specify what would happen if the regulations change. It grants a right to Badgehurst to build, to dig graves indefinitely, and says, well, for the first 2 years it's at this price, and after that it's at whatever price is our going rate. That's what it says. So it doesn't say we have an exclusive right for 2 years to dig. After that, it's all open to regulations. It says that we have an exclusive right forever to dig, and the price is fixed for the first 2 years. Now, if it was contemplated that the covenant to comply with rules and regulations could include a rule that says only the grantor, only the owner of the cemetery can dig graves, that would be completely unnecessary. All that clause 4 would have needed to say was the first 2 years the grantor won't charge more than £150 for digging graves. That's all that it would need to say. What it wouldn't have needed to say is, crucially, the grantor shall have the exclusive right to dig graves in the said plots of land. That would be quite unnecessary if that was or could or was contemplated as being something that could be imposed simply by including it in rules and regulations, which in the context of a private cemetery simply means terms and conditions of the cemetery. We're calling it rules and regulations, it just means terms and conditions.
Yeah.
So, just on this point of the specific and the general provision, I dealt with it in my skeleton argument, and I referred to the principle in my Lord Justice Lewison's book on interpretation of contracts, which is referred to in 7.46 concerning contracts or similar where there are specific provisions and general provisions and a potential for the conflict. And in the bundle of authorities I provided, I'm conscious that this is very much teaching English grandmothers to suck eggs and refer to the Joshua's own book, but at page 99 in the authorities bundle that I provided, we see the beginning of a discussion about general provisions and special provisions. And the summary, which Lord Justice Lewison gives at the beginning, is that greater weights given to specific provisions. And then there is a quotation from an Irish case, Welsh and Bowmaker, which is in the footnote at 111, and that, in my respectful submission, encapsulates the proposition of the rule of construction with which we're concerned, principle of construction, where you find a particular situation dealt with in special terms, and later in the same document you find general words used which could be said to encompass and deal differently with that particular situation. The general words won't, in the absence of the indication of a definite intention to do so, be held to undermine or abrogate the effect of the special words. Common sense way of giving effect to the true or primary intention of the draftsman, for the general words will usually have been used in advertence of the fact that the particular situation has already been specially dealt with. Now, in my submission, it's likely here that the parties didn't contemplate the possibility that the regulations, rules and regulations which are referred to in that covenant, would include a regulation saying only Badgehurst could dig graves, because they were dealing with that specifically in clause 4 and gave that exclusive right to dig, which they didn't need to do. They could have just said something.
But clause 4 was directed, as you rightly pointed out and won on, only to Badgehurst.
Well, indeed.
And therefore, if this was ever going to pass on to third parties, it's not a specific clause in relation to digging, because that went with Badgehurst. So therefore, it has to be covered by rules and regulations.
Well, does it?
If there is to be anything, and the judge then said, "Well, this looks like it's getting difficult. I'll leave it until I've got regulations to decide," which, speaking only for myself, I thought would be a perfectly sensible judicial approach.
But that doesn't answer the question of whether or not the regulations can do it in the first place. So that isn't in my respective submission.
Mr. Kitson says in his skeleton, well, the regulations might, for instance, say you've got to appoint some professional to oversee the digging. And that sounds so, it's right, trustees can't just do what they like. The manner of digging might be, or times of digging might be legitimate subjects for regulations. It might be legitimate to say graves must be so many feet deep, or graves must be so many feet wide, or there must be so many feet apart.
My Lord makes a point that I was going to make myself. That when one thinks of rules and regulations in the context of how you would run a cemetery, then it's the manner in which things are done that one expects to be regulated by the rules, not who does them necessarily. So it may well be that the parties, that the trustees, when they said, when they covenanted to comply with the rules and regulations, they were effectively allowing Badgehurst or a subsequent owner to say, so deep, so wide. Don't dig them at 3 o'clock in the morning, that kind of thing. But that's qualitatively different from the question of who does the digging.
And your point is directed only at that question, is it?
It is, because that's ultimately the dispute. I mean, this really wouldn't have, this whole litigation wouldn't have arisen if Mr. Demetriou was either prepared to allow my clients to make their own digging arrangements, or was prepared to dig himself at the sort of rates that my clients could obtain from.
But that's different, isn't it, Mr. Gately, from actually complying with certain standards. The price to one side, it's different to say it is right that every grave shall be dug to the depth of 6 feet, that the digging shall only take place during the hours of 8 to 5, that the regulations are quite pertinent in that respect.
My lady, yes. I don't say that those sorts of regulations wouldn't be within the scope of a covenant to comply with the rules and regulations of the cemetery.
But what if, and I'm not for a moment suggesting this has happened at all, but if you're talking about a completely different set of the trustees with different graves who have serially employed useless contractors, and therefore the cemetery owner says, right, I'm sorry, I'm now going to have to come over and take control and impose a third-party contractor on you in those circumstances. Your form of declaration would avoid that forevermore, and this is a 999-year lease.
Well, it would. My form of declaration.
It would if you take out as they were at the date of the trial.
But my form of declaration wouldn't prevent the cemetery owner from setting a series of standards and requiring that they be complied with. And doubtless, if they weren't complied with, then the remedy for that would be to go off to court and get an injunction to prevent my clients from digging until they were complied with. But that's.
So how would the standards be described?
Well,
as regulations?
As I say, it's a private cemetery. We're really talking about terms and conditions, but those rules and regulations, aka terms and conditions, I don't say they couldn't include a provision that graves be dug at to a certain height, certain depth, or whatever it is. Unless they would be that would be a.
You're talking about a deletion of words rather than an insertion to specify those conditions that it would be reasonable to impute. And on the basis of your declaration, then you could proceed at will. for 909, or whatever's left in 999 years.
Well, all that the declaration would say, with my deletion, is that the defendant is entitled to, reading the word himself, insist on digging graves for the association pursuant to his regulations for the cemetery. That's not to say he couldn't say that graves have to be dug in a certain way. That wouldn't be.
And not entitled to say, and if you have failed to dig properly for 5 times in a row, I will then impose a third-party contractor. I mean, all the judge is saying is that there are a million different ways in which people who are not getting on at the moment might fall out in the future. Regulations might be unreasonable, might be plainly unreasonable. The judge has made it clear there can't be a derogation from grant. He's tried to protect your clients in that respect, but he's also pushed off to the future those things which should be left till regulations come about.
Well, my lord, that still begs the question, with respect, as to whether or not
There might be some circumstance in which he could insist to dig a grave.
Well, you have to say, don't you, under no circumstances can regulations entitle Mr. Demetriou to insist on digging the grave.
Well, that's what we do say.
Yeah. Because if you can't say that, if you can't put it that high, then, as my lord says, it's really got to wait for regulations. I mean, if the regulation said, you can't dig a grave less than earlier than a week after the decease, which would make it impossible for your clients to arrange a burial in accordance with their religious traditions, would no doubt be a derogation from grant. I mean, there might be all sorts of regulations that you could legitimately object to.
Well, there would certainly be regulations potential regulations that we might be able to object to on the basis that they derogate from the grant to us. But the regulation that this is directed at, and perhaps the answer is that the exact language of the declaration that we ask the court to adopt is not as well formulated as it ought to be, but that nonetheless, if one accepts the broad proposition, the court should adopt a different form of declaration which allows for the possibility of the sort of regulatory restriction that my Lord Justice Dingemans suggested without the general proposition. So it may be that one ought to look again at the exact form of the regulation. But the exact form of the declaration. But it's important in my submission to grapple with the underlying question, which is whether, as a matter of general, the width of, and this was the defendant's case below, that the width of the covenant to comply with the rules and regulations means that it's open to an owner of the cemetery, and Mr. Demetriou in particular, to simply say, only I can dig graves.
Yeah. So in your cases, there may be all sorts of things that the regulations can do, but the one thing they can't do is to say that the cemetery owner has the exclusive right to dig graves.
That's right. And you can't do that because that was specifically granted as a commercial bargain separately. And I mean, one can see that if one considers the position in the first 2 years of these deeds. In the first 2 years of these deeds, we know that there's a specific price. Now, what if Badgehurst, at the end of year 1, had turned around and said, well, actually, we don't want to charge you £150 or whatever it is. We want to charge £1,500. And we're going to do that because our regulations say only Badgehurst can dig graves, and that's our price. Could they do that? Well, the answer must be no.
Of course not. It would be a clear conflict with that.
It would be a clear conflict with that. But that is one of the reasons, a significant reason why it can't have been contemplated that the covenant to comply with rules and regulations would have encompassed a regulation which says only the owner can dig graves, that can grant the exclusive right to dig that was granted to Badgehurst as part of a commercial arrangement. Given that the scope of that covenant must be the same within the first 2 years as subsequently, if it wouldn't have been possible, if the covenant to comply with rules and regulations in year 1 wouldn't have included a regulation to allow Badgehurst to dig the graves even if they were charging £10,000 to do it, then it never has, and didn't do subsequently. And that is, in my estimation, a significant reason which the judge didn't grapple with as to why the covenant doesn't have the room to regulate that the judge referred to doesn't go so far as room to insist that only the owner of the cemetery.
And when you're dealing with a long-term agreement like these, 999 years, a clause 2.1 type, 3.1 type obligation allows for some flexibility to deal with things that you couldn't possibly imagine at the start of a term of the best part of 1,000 years. You just have no idea what's going to happen over the next 1,000 years. So you've got to have some flexibility to cater for circumstances as things change.
My lord, yes, but if, and this is unchallenged so it must be right, if the commercial bargain that was reached between the parties when these deeds were executed was that trustees would have a 999-year right, and Badgehurst, not anybody else, Badgehurst would have an exclusive right to dig the deeds, and that's not a right that was going to pass to success, right to dig the grave, sorry, and that's not a right that was going to pass to successors, then it follows that what the parties weren't contemplating by referring to rules and regulations, that somebody else could get that right by dint of making a regulation to that effect. Because it may be that when this contract was entered in, these deeds were entered into, the Badgehurst could have thought to themselves, well, it may be that even when we've sold the cemetery, this is a source of income to us. We can, even if we don't own the cemetery any longer, then we have, and we may want to exercise, this right to dig graves. Now, in practice, that's clearly not how things have turned out. But it could have been at the time. One can't say, from looking at the deeds, that wasn't contemplated. Because, of course, somebody's going to have to do the digging if Mr. Demetriou doesn't. When in the 6-month period in which in fact, my clients were digging graves themselves because Badgehurst had passed it on, and the company they'd been passed on to was sort of collapsing before liquidator went in place. They used a chap called Mr. Edward Daly, who was one of the witnesses, who's their groundsman effectively to dig the graves. They were always going to have to pay somebody to do it. It could be that Badgehurst was reserving this exclusive right to itself for as long as it wanted to. It's a company which had potential to exist for 999 years, I suppose, it being not a real person. So the mere fact that there would be future things would happen every 999 years that one contemplate isn't a reason in my submission to conclude that the parties intended when the trustees covenanted to comply with the rules and regulations to oblige the trustees to comply with a regulation which says only the owner for the time being can dig graves, when there's an exclusive right actually given to Badge House, which it may or may not want to exercise even after it's ceased to be the owner. And I can come back to the point that if that's not what it meant during those first 2 years, and it can't have been because of the conflict, then it's never what it meant. It can't have a different meaning. And the other matters that I've pointed to below and point to now is that if there is doubt there, then we are entitled to rely on the contra preferentum principle. Clearly that's a principle of last resort, but if there is doubt, then we rely on that. And for two of the deeds, the last two, granted in 2000 and 2004, we can also rely on effectively the statutory contra preferentum principle applying to consumers, which is contained in the Unfair Terms and Consumer Contract Regulations 99, which was in force in 2000 and 2004. If there's any doubt about the meaning of a written term, the interpretation which is most favourable to the consumer shall prevail. So that's the substance of my submissions. I do say that the change to the declaration which we proposed in the appeal notice is appropriate, but if the court were minded to make some other change to the declaration that both reflected the principle that I'm asking the court to adopt, but was better thought to represent the point where the court ends up in the declaration that I've proposed, then I don't demur from the court doing that. The declaration, of course, was drafted in the light of the judgment below. I'm seeking to amend it because I say that the judgment below is wrong. But if the judgment below is wrong, then...
Well, if we were to decide the judge was wrong, then we would frame an appropriate declaration.
That's all I seek to say. May I just turn my back for a moment?
Yes.
The further point that I'm asked to make is that that clause 4 comes with the proviso that if the grantor shall fail to dig graves within a reasonable period of request.
Yes.
That too is a reason to conclude that what's contemplated by the covenant to comply with rules and regulations can't go so far as to be a rule that says only the grantor can dig.
The judge made that clear.
Well, he made it clear in that he said...
There was nothing in the judgment which was inconsistent with that proposition that you've just advanced. If they attempted to draft regulations like that, then it would be a very short further hearing.
But yes, if they attempted to draft regulations like that, then there would be an argument for challenging them on the basis of derogation from grant. But it's also a reason to infer that the parties can't have contemplated when they included a covenant to comply with rules and regulations, that could include a regulation which says only the grantor could do, because there are specific constraints on the right that's actually being granted in clause 4, and therefore my submission can't have been contemplated by the parties, that the rules could simply provide that the grantor can take. And so I say that that's also a further reason to treat clause 4 as precluding the possibility that such a regulation could be included. Unless I can assist any further, there's my submission.
Can I just ask one question on detail? I mean, it's slightly off the range. There's been reference in the submissions about private cemeteries being unregulated. Are there no regulations which govern anything? For example, the digging of graves or...
Most private cemeteries were created under private acts of parliament, and those are subject to a regulatory regime. I could have told you chapter and verse in 2021.
I didn't know that.
But they are because they effectively incorporate a general act, and I will try and remind myself of exactly what it is.
Well, we've got a report, haven't we, in the supplementary bundle, and there is a section of it that deals with statutory requirements applicable to this cemetery at page 213. We've got the Burial Act 1857, the Forgery Act 1861, Registration of Burials Act 1864, and so forth. But that's mostly about record keeping and not exhuming bodies which have already been buried.
It's a very strange situation, and it was common ground below that the summary of the law in that report is accurate. There is, in fact, one of the witnesses in this case, Baroness H, has actually introduced a private act into she's a member of the House of Lords, private act recently to try and effectively bring over the regulations that would apply to local authority-owned cemeteries to private cemeteries. But in the peculiar example of this cemetery, and I think some others, but probably not very many, which aren't owned by the church, aren't owned by local authorities, and weren't set up under private acts of parliament, there is very, very limited regulation indeed. That's the conclusion that was drawn. So the government was able to appoint the author of that report, who wrote a report that was quite critical of Badghurst, who were then the owners, not, I should say, critical of in relation to the areas of land that my clients effectively control. There's very little that could be done to actually implement the recommendations in that report if they weren't implemented voluntarily. It's not a very satisfactory situation, but it appears to be the situation.
Thank you very much.
Yes, Mr. Kitson.
Great.
So it seems to be accepted that your client can have regulations which lay down requirements about the manner and times at which graves can be dug, and no doubt other things as well. The only point that Mr. Gatti is taking is that the regulations cannot give your client the exclusive right to dig.
Yes. Can I start by, and my submissions will be brief, can I start by returning to what the commercial bargain was between the parties when they entered into each of these deeds, save for the very first deed that didn't deal expressly with digging rights. It's a right to have bodies buried in the ground. It doesn't come with it. There doesn't come with it a right to dig the hole in the ground in order to inter those bodies. In the deed, there is a separate provision, certainly as far as the original grantor is concerned, that they have the exclusive right to do the digging, and there's a proviso in the event that they don't do it in accordance.
If the right were the right to have bodies buried, you may well be right, but the right is expressed as a right to bury bodies.
A right to bury bodies, yes, that's right. But the way that the case has evolved and the judge's decision below is that it is a contractual right only to dig those bodies, dig those graves for those bodies for the original grantor. That is the position as it is. The deed does not go on and deal with what would happen once, or in the event of, successors in title coming on the scene. And of course we own the land. It is our land, and there are rights to bury bodies on that land. And what we know from the regulations, going back to the commercial bargain, is that the regulations specifically single out regulations of successors in title, as well as regulations of the grantor. And we see that at paragraph 2 of the deed. So the commercial bargain is very much seeing these regulations over the currency of a 999-year grant as being regulations that could be introduced not only by the original grantor, but also regulations introduced by a successor in title. And the way that the case has evolved, a successor in title doesn't have the benefit of clause 4, and therefore there is no provision in this deed, we say, about digging in a successor in title situation.
Unless the right to bury bodies carries with it
Unless
a right to dig.
Unless it includes a right to dig. But we know certainly in the first, as long as the original grantor remained the owner of this land, then there would be no right to dig, because that right would be covered by clause 4 of the deed.
Yeah. But what's the position with the deed that we see at pages 164 to 5, which doesn't have a clause 4 in it?
Well,
It's the grant is the right of burying bodies. There doesn't appear to be a covenant to comply with regulations. There doesn't appear to be a clause 4.
no.
It's just the grant of a right to bury bodies. So, do you say that trustees can't exercise the right of burying bodies?
No, I don't think I can say that in relation to that one deed.
And presumably, you can't make them comply with regulations
No,
under that deed.
under that particular deed. I must accept that, my lord. It is in different terms from the other deeds.
There's a reference to rules and regulations for the monument sizes, but that's obviously not the digging case.
No, that's right. It doesn't deal with digging unless we were able to seek to introduce regulations in our capacity as the owner of the land. But that's not. I mean, that moves the scope of what the Court of Appeal is asked to consider beyond what is there on the paperwork. My Lord Dingemans made a important point in relation, as did my Lord Lewison, Lord Justice Lewison, did make an important point in terms of the need for regulation to be able to regulate over a very long period of time. And what we say is the judge was absolutely right in the way that he dealt with the point and made the declaration in the way that he did following the giving of his judgment, because there is nothing in the deed which limits the digging entitlement after in the event that the original grantor transferred the land. And there are any number of situations that could arise over that 1,000-year period. I mean, for example, we know that there is a move to regulate in this area. We don't know whether or not, when regulating in this area or these cemeteries have to be transferred to local authorities, that there may be particular requirements that the local authority is in charge of dealing with the digging of graves and appointing contractors in order to be able to do that. there's any number of circumstances that could arise which this declaration would preclude in relation to this particular parcel of land, without there being a conflict necessarily with the sorts of regulations that could be introduced in the future. The judge was right to consider the regulations that were before him at the time, because over this 1,000-year period, and this declaration would have effect through that 1,000-year period, to limit the right to determine that you can and cannot do something by way of regulations over that long period. But my Lord, I think you have that point. You made it. So I'll move on from that. In terms of the point that my learned friend was making in relation to Badgehurst still being able to insist on having the right to dig the graves, well, the difficulty with that is that Badgehurst doesn't own the land anymore. And so if it wanted to assert a right of that character, it would have to come onto our land in order to do that. I don't know the terms of the transfer. We haven't seen the terms of the transfer, but it would be an unusual situation if they would be able to exercise that right once they had passed on the land, and all sorts of arguments may arise, for example, in relation to trespass if they did seek to insist upon that right. Mm. So that point we say doesn't work. In our skeleton argument, Ms. Kuhl and I have set out our position in relation to the exercise of discretion, and that it
on the making of a declaration.
Absolutely,
yes.
and that extreme caution needs to be adopted.
Yeah.
And extreme caution in this case, because of the longevity of the effect of the declaration. And we say that the judge was absolutely right to determine the position insofar as the regulations that were in force at that time. And indeed, it is my learned friend says that this isn't hypothetical because other regulations were introduced at a later stage. I haven't seen those regulations, Your Lordship, and my lady, you have not seen those regulations. But if there is an issue in relation to those regulations, then it would be a matter that would need to come to the court, and indeed the judge recognises that at paragraph 48 of his judgment. And we say that he was perfectly right in doing that. And of course, it's one of the reasons we didn't proceed with grounds 1 to 3 of our appeal. My Lords, I'm very conscious that you have questioned my learned friend and put points to him. I don't want to take up too much of the court's time on this, but what I would say is that when you go back to the judgment that the judge made, it's very clear from paragraph 45 through to paragraph 48 that he was absolutely right in the approach that he adopted, and indeed what he envisaged would happen in the event that regulations were introduced, and gave a strong indication to the respondents to this appeal that the derogation from grant issue would be one that would need to have to be considered, but it would need to be considered in the context of what exactly it was that the regulations were saying could happen. And in an interesting way, you can introduce regulations dealing with all of the things that's conceded the regulations could deal with, but not the one thing which once the land has been transferred, it being a contractual right as between the original grantor and the original grantee, but once it's been transferred, the deed doesn't deal with that at all, unless, as my Lord points out, you can construe burying bodies as including the right to dig the hole for those bodies. It's a very significant point because it goes to how you regulate unregulated cemeteries.
Sorry, what's the significant point?
Whether
the right of burying bodies includes the right to dig a hole? Or...
My Lord, no, it's a significant point in relation to what the regulations can and cannot do.
Right, but you say, although it's a significant point, it needs to wait until there are concrete regulations to consider.
Absolutely. Because the effects of...
And at that point, might it be necessary for somebody to decide whether you should construe the right to bury bodies as including a right to dig a hole?
That may be one of the arguments that arises in that context.
But now is not the time.
Now is not the time. Unless I can assist your lordships and my lady any further, they're my submissions. I rely, of course, on the points that are advanced in the written argument from my junior and I.
Could I just ask about paragraph 47 of the judgment, please? Can you give me the cross-reference to the claimant's issue as it was drafted?
47.
47. The result is that the defendant cannot insist on digging graves for the association, and the claimant succeed on the issue as it was drafted.
Oh. Paragraph 80. Yeah, paragraph 20, my lady.
Of
The judgment.
the judgments.
Page 88.
So which part of paragraph 20?
1.
No, it's 2. If the
Forgive
right
me,
was
2.
not granted to Badgehurst's successors in title, whether the defendant can insist on digging graves for the association and charging for doing so, pursuant to regulations for the cemetery. So that wasn't in terms limited to the current regulations.
No, it wasn't.
Pursuant to regulations.
But we say the judge rightly had to deal with what was in front of him and set the current regulations out in his judgment earlier on, and that was the outcome, and it can't be criticised.
And the reasoning goes a very long way to giving comfort to the respondent's client.
Of course it does.
And that will bind you as an estoppel between the parties and their privies.
Absolutely.
Yes.
Thank you.
Thank you very much, Mr. Getty. Yes, Mr. Getty, do you wish to reply?
Only 2 very short points. Firstly, it was suggested that if there was statutory regulation, that would somehow impact on this issue. Of course, it wouldn't. If there's statutory regulation, the parties will have to comply with statute. That has no impact on the meaning of the deeds they entered into. And secondly, it was suggested that it was unlikely, or not, it didn't work for Badgehurst to continue to have digging rights. Well, it may be that they wouldn't want it, but it would have been perfectly possible if they had wanted to reserve any necessary rights of access in the transfer of the cemeteries. It certainly could work if that had been the party's intention. Nothing else to say.
All right. Well, thank you all very much for your arguments. We will consider our decisions. We will circulate a draft judgment in due course, which will be your opportunity to correct our English but not our reasoning. The draft judgment will come with a stern embargo on its use before hand down, which means what it says. We would hope that in the light of the draft judgment you will be able to agree an order disposing of the appeal, but if you can't agree a form of order, please make written submissions, short ones, and we will make the order that we consider to be appropriate. Thank you very much.